When can a school, consistent with the First Amendment, non-renew an employee for their speech? What happens when the high school football coach doesn't like his daughter's middle school social studies curriculum? Jamie, are you ready for some facts about nothing to do with football?
Good. I'm glad. But we're so good when it comes to talking about sports, aren't we?
Oh, it's so good. Football, I feel like I could actually do a decent job on.
Well, I could not. So I'm kind of glad that this case actually doesn't have very much to do with football itself. It just has a football coach involved. So this is a case today we're going to talk about. It's a recent case out of Massachusetts about a football coach who had some problems with his daughter's middle school social studies curriculum, which led to some conversations and some emails and ultimately some bigger problems, like the football coach's non-renewal. So today we're going to be talking about the case of Flynn versus Forrest, that's a cool name. Flynn versus Forrest. Yeah. All right. Welcome to Chalk and Gavel, everybody, where we explore how the law shapes education one case at a time. I'm Jamie Cudlitz. I'm a former middle school math teacher and principal.
And I'm Chris Thomas. I've been a high school English teacher and a school attorney. Now we're both professors of educational leadership, bringing you the fascinating stories connecting the courtroom to the classroom.
Chalk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
Okay, welcome back, everybody. It is that time of year. The Education Law Association's annual conference is coming up in Kansas City, November 5th through 8th this year. This is a great organization. It's where Chris and I met. We're both highly involved in this organization. It's great. You should totally check it out. You can go to educationlaw.org to find out more about this great organization and register for the conference if you want to hear about all of these kinds of topics that we talk about on the show. Tons of experts, tons of practitioners. It's an incredible organization, hundreds of people, great presentations. You should come check it out. Now, one of the things that Chalk and Gavel is starting to do at these Education Law Association annual conferences is we record a live episode there. And
right, we've done it once.
We've done it once. Yeah, we're going to try to do it again. But this time we want to change things up a little bit. We want to get all of you involved. So we were thinking about doing a little listener Q&A episode.
A pop quiz, if you will.
Hey, we'll call it Chalk and Gavel Pop Quiz. And it could be...
Well, I guess they're quizzing us, so...
Yeah.
It's fine.
Well, it's still a pop quiz. It's just who's taking it. So, we're going to have lots of great experts in education law surrounding us at this conference. So send in your questions and we'll try to get them answered on that special episode that we do. You can get in touch with us a variety of ways. You can reach out to us through social media at Chalk and Gavel. We've got a Facebook page, Instagram, X. You can email us. Our email address is chalkandgavel@gmail.com, or you can use our feedback.
Spelling out the and, not just an ampersand.
Yes, chalk and A-N-D, Gavel. Or use our feedback form on chalkandgavel.com, also spelled out with the and. And we'll throw all these links in the show notes too. So we would love to hear from you. If you've got questions about stuff that's going on in the education law world, send those questions our way and we'll try to get them included in our live episode that we'll record in November.
Pretty exciting.
I think so.
And with that, other reminders, please don't forget to rate and review Chalk and Gavel. You can check us out on YouTube. Give us a thumbs up there. We also have our teaching guide up on the website, chalkandgavel.com. We'd love it if you would consider using Chalk and Gavel in your classes or professional development. And if you're liking what you are hearing, consider supporting us on Patreon for just $2 a month. You can go to patreon.com/chalkandgavel to help us keep this show going. So with that, Jamie, I think you've got our bell ringer today.
I have got the bell ringer. So today we've got a federal court decision out of South Carolina that's kind of representative of a lot of the stuff that's going on around the country with respect to these debates about classroom censorship and these, the so-called divisive concepts. So this decision came down on September 8th, so just a few weeks ago. It's the South Carolina NAACP versus Weaver case. All right. So here's the background. In 2021, South Carolina failed to pass bills that banned certain curriculum covering race and gender, things like that. So instead, what lawmakers did was they tucked those things into the state budget.
Huh.
All right. Yeah. They got a little
Interesting.
sneaky. Yeah.
Yeah. That's part of the evolution of these laws because they realized, states did, that they didn't have the authority to regulate the speech directly. So they
tie it to funding.
They do have control over funding, which gives them a little bit bigger of a lever.
Yeah. And it's basically what they're saying is like, if you get state funds, here's what are your obligations.
Right.
And so if you don't meet these obligations, you're running the risk of losing all your funding. Anyway.
It's a big risk.
So the provisions in this part of the budget prohibit schools from using state funds to teach concepts like one race being inherently superior to another, or that individuals bear guilt or responsibility for historical wrongs because of their race or their sex. It's all pretty similar to a lot of other bills that have become law or proposed bills that are popping up around the country. Okay.
Yeah.
We're seeing this everywhere.
Language sounds very familiar to what Florida passed in our parental rights laws and Stop Woke. And it all comes from executive order from the first Trump administration, these divisive concept ideas.
Yes, exactly. So in the South Carolina case, we've got several plaintiffs here. We've got the South Carolina NAACP. We've got students who wanted to take AP African American Studies. We've got an author whose book was banned as a result of this. And there's other educators involved. They're the plaintiffs, okay? And they challenged this law, saying that it violated the First and 14th Amendments. So first being the speech one, 14th being equal protection, because that chilled discussion of race and it leads to the removal of books from classrooms and libraries and things like that. So that was the issue that they took with this law or these provisions in the state budget. So here's what happened. This is interesting. The federal court dismissed the case, but not on its merits, on standing. Okay?
Oh, yeah. That's been a huge hurdle for a lot of these lawsuits.
Yeah, popping up all over the place, this kind of stuff. So in other words, here's what we mean by that. The judge in this case said that the plaintiffs couldn't show a concrete injury that the court could fix. All right. So remember, we've kind of talked about this before. In order to kind of bring one of these lawsuits, you have to say that you're being harmed by something that is happening, right? And the court basically said, you can't really show us that this harm is actually taking place here. And so one example is the AP African American Studies course. It ended for multiple reasons, not just the budget rule.
Sure.
Right? So striking down that provision wouldn't necessarily restore that course, okay? Similarly, one of the books that was removed under separate district policies. So striking down that provision might not have reinstated that book. It still could have been removed because there were other things that got that book removed. And then the educator's claims of fear and self-censorship just weren't enough to count as actual legal injury, at least in that district court's eyes.
Right. That's the piece that gets me because, like, you and I both know how much concern educators have about these laws. And when there's not clarity, when there's ambiguity, what do? They steer as far away from controversial stuff as they can.
Yeah.
And
exactly.
Like, to me, that's a real injury because I've seen it. I've lived it.
Yes, exactly. The court, however, does not feel like it is a real injury.
Yeah.
So
no one's nominated me to the federal courts yet.
No, not yet. Not yet. So what does this mean beyond South Carolina? Like I said before, these laws aren't necessarily unique. Chris talked about it. Florida, North Carolina, there's one that's almost identical that just came into effect this year, North Carolina, Tennessee, and there's other states that have passed or have proposed similar restrictions on classroom discussions about race, gender, American history, things like that. And courts are kind of all over the place on these things. Like you said, it leaves educators in a really tough spot. All right, because the laws, like you said, are often vague. There's a lot of very subjective wording in there. But this fear that educators have of complaints or discipline, that's what's kind of driving and shaping so much of what's happening and what's not happening in schools right now. So one thing I do want to point this out. Like you kind of might be wondering, what is the big deal with these laws? Because on their face, they can kind of sound a little reasonable. So, because the laws use phrases like, you can't teach that one race is superior to another, and things like students shouldn't be made to feel guilty about their identity. Well, it's kind of hard to find fault with those kinds of statements on their face.
Yeah, but there's 6 other things on that list, right?
There are 6 other things on that list. They're kind of similar in how they're worded, but the concern is less about what is written, okay? And it's more about how all of this stuff actually plays out in the real world, which is where we're all living. Right.
Those are what the words on the page say, but what do the people who are promoting these laws say they do? Right.
Exactly.
And if you look at the difference between those two things, you see that these laws are really
they're tied to some other.
They're tied to a very specific political agenda that is seeking to kind of remove other viewpoints in many situations from the curriculum.
Yeah.
And so, talking about the harms.
Right. And I picked this case as our bell ringer because it's very similar and tied in many ways to the case that we're going to explore today.
Very
in
true.
depth. Right. Just to kind of wrap it up, like these laws, the wording is broad, it's vague. They use words like discomfort or distress or whatever, but it's so broad and it's so vague that nearly any meaningful discussion of things like slavery or the civil rights movement or, Jim Crow laws or sexism or systemic racism, like they're so broad and vague that any of those discussions can trigger complaint after complaint after complaint. And that has a chilling effect, right? Teachers
100%.
Self-censoring or their school boards will do it for them. And they often go much further than they have to just to kind of play it safe and avoid those kinds of challenge, right?
The legal gray areas.
Exactly. So what does that lead to? Getting rid of books, other resources, watering down lessons, avoiding hard or complex discussions. And I don't know, I feel like the less exposure to complex ideas and the messiness of history and things like that, like the less we're doing to help kids learn how to analyze, how to think critically, how to form their own thoughts and opinions based on exposure to a variety of ideas and perspectives. So, while that wording might seem noble kind of on its face, I think what we're seeing a lot of is the opposite. The effect is the opposite. Classroom discussions are being narrowed instead of opened up. And we've got to pay very, very close attention to these things.
Right. And you and I have said it in the past, like the remedy to speech you don't like is more speech. And this is taking the opposite approach.
That's what it feels like, right?
Yeah.
Yeah. So anyway, that was, this is just one court's opinion, and the courts are all over the place on this topic. So we're going to have to just kind of wait and see how all of this shakes out over the next number of years. And of course, we will be there to let you know what's going on and help you make sense of it all.
I feel like we've already been covering this for years, but it's probably because we have been.
We have been. This is where we're at.
I know it keeps evolving, right?
Yes, exactly.
Yeah. But speaking of controversy over the curriculum, what's our case today?
Yes. So we've got another case that deals with this kind of stuff. We've talked about parental concerns with the curriculum before. We've talked about teachers getting in trouble for the things that they say. But what happens when you've got both?
Right. This is a slightly different angle.
It is. We've got parental concerns. We've got teachers getting in trouble for the things that they say. Hey, you can have your cake and eat it too here on Chalk and Gavel.
Yeah, 2 birds, 1 stone.
There you go.
Mixed metaphors.
Yes. Or as one of my old dear departed friend used to say, could get 2 birds stoned at once. He did not know that he was not saying that intentionally. He just could not get the phrasing right. But anyway. So what happens when a high school football coach gets let go after he objects to his middle school daughter's social studies curriculum? You ready to find out?
I woke up ready. Let's go.
Excellent. So here we are. This takes place in Dedham Public School System in Dedham, Massachusetts. Chris, you have an interesting fact about Dedham School System, don't you?
I do, yeah. So when I was doing my research for this case, I turned up that Dedham is apparently the oldest public school system in the United States, according to them. at least. But so in 1645, the town of Dedham authorized the first taxpayer-funded public school in the United States. So that's pretty cool. I think.
That is really cool.
Right?
Yeah, that is pretty crazy. So, all right. So let's fast forward about 350 years. Fall of 2020, we've got somebody named David Flynn. He's the head football coach at Dedham High School. All right. He coached from 2011 to 2019. But due to the COVID pandemic, there is no football in 2020. All right. Every year, he received a modest stipend for his position, which in 2019 was a little less than $10,000 stipend. Okay.
Really?
Yes. So here's an interesting little twist. Flynn, not only the high school football coach in Dedham, he's a Dedham resident, and he is the father of 2 children who were enrolled in the district, in the public schools in the district. His daughter was in 7th grade at the time at Dedham Middle School. Okay? So here's where the potential trouble starts. A few weeks into the new school year in 2020, David Flynn's wife reached out to the school and asked for the syllabi for all of her daughter's classes. The principal responded a few days later and directed her to the district's website for the course descriptions. At the time, the website said that 7th graders took World Geography and Ancient History 1 for social studies. But Flynn was aware that the course had been changed to something called Social Science and World Geography. So already there could be a little bit of a discrepancy here between what is public-facing and what is happening in the schools, okay?
Right. Which is I think the kindling here, right?
That's the kindling, exactly.
Because there's some smoke underneath all of this, because we don't know why they asked for the syllabi at this point, right?
Right. Maybe they had a hint of something that they weren't necessarily too pleased about, so let's start digging into it. So something's definitely going on because the Flynns have raised some concerns about the social studies course with the teacher. The teacher went to the principal, whose name is Karen Hillman, and the principal then reached out to the Flynns to try to alleviate some of their concerns about their daughter's social studies class. Okay. So she sends an email to the Flynns.
Always emails.
Oh, here we go.
There's so many emails.
Dance like no one's watching. Email like it's going to be read in court.
Email like it's going to be read on Chalk and Gavel. I think we need to change it.
Then let's read that email. So the principal says in that email, she says, "We always appreciate it when parents engage in dialogue about course content, and that while social studies is critically important, it's also at times the most controversial content that we teach in schools." All sounds good so far, but the email assured parents that, quote, "the content we are sharing with students is based on and reflects current state curriculum frameworks and is presented objectively to our students," unquote, right?
Uh-huh.
Mm-hmm. The email ended by saying that the teacher's role is to support students in making sense of the world, being informed consumers of information, and drawing their own conclusions.
Okay. So kind of like the critical thinking stuff you were talking about in the bell ringer.
Exactly.
Yeah. That choice of words like is to be objective or presented objectively. I think I am anticipating where the Flynns are coming from, because maybe they think things are being subjective.
I think that is a fair assumption. So for his part, Flynn, dad, coach, responded to the principal that he was disappointed that he had never been informed that his daughter was taking a new course because the website hadn't been updated.
Maybe there's concerns about like how things went down. So not just the what, but the how.
Exactly. He had also hoped that the middle school was teaching these subjects correctly. This is his words, I hope. Quote, "These subjects are being taught correctly, objectively, and with the understanding that students who are this age or whatever, that the schools have an understanding of the age range of the kids and how to approach this kind of content." Right?
Sure.
Okay. So at this point, Flynn and his wife obviously have concerns over the social studies curriculum, how it was presented or not presented publicly, and then they've got concerns over its delivery, essentially. But that's, right now it's pretty contained. It's just, parents, principal, teacher. Okay.
Right, yeah. It seems like, there were concerns about the curriculum. That, they brought those concerns to the teacher. Teacher, not feeling like they could handle it themselves, went up to this principal supported their teacher. Maybe they did some course correction at that point. Things seem to be going pretty well so far.
Yeah.
Every time I say that, though.
Yeah, every time you say that. So 2 days later, here it goes. Flynn
Only 2 days. Okay.
Yeah, just 2 days.
So I guess things weren't going that well.
Not for some people. So 2 days later, Flynn emails the superintendent. Okay. This guy's name is Michael
He's the
Welch.
head high school football coach, which probably has a bit of like status or position within the community, right?
I don't know.
Depending on how big of a football school you are.
Exactly. So Superintendent Michael Welch gets an email that requests his professional opinion regarding the concerns that Flynn has raised with respect to the curriculum, social studies curriculum. So Welch responds by admitting that the district had not done a good job informing the community about the state's adoption of this new history and social studies framework. And he admits that the website hadn't kept up with the changes. Okay.
Sure. Understandable. Happens to the best of us, especially when the state is changing the requirements and you're trying to catch up. Like your website and your public facing stuff is probably not the first thing you're thinking about when you're trying to meet these new state requirements, right?
Right. And the state requirements are constantly changing. Okay. And typically state requirements, when they do change, often change at the worst possible times. Like they don't come out until July 28th. And they're like, oh, by the way, you've got to implement all of this stuff in the next week and a half. And so
good luck.
Like on one hand, we're like, listen, man, the school did not, wasn't transparent and didn't keep up with their end of the bargain, communicating to the public. On the other hand, like it's important to call attention to the fact that school districts are oftentimes backed into corners and presented with really, really challenging timelines, almost impossible timelines to meet. So like,
particularly
I get
with limited resources.
Exactly. So Flynn responds to the superintendent by saying, there's a lot of concerned parents out here regarding the social studies curriculum and history framework, and that teaching controversial issues needs to be done in an objective manner. He also expressed concern about his daughter's ability to do that. Okay. He expressed concern basically saying, my daughter's teacher has an emoji on her class website, and that emoji is wearing a Black Lives Matter shirt. So, he's kind of saying, I don't know if this is being taught objectively.
Right. Okay. So it sounds like he's worried about the political leanings of the class then. So it's not just a process issue, it's a content issue for him.
Exactly.
Okay.
Exactly.
And I mean, if it's just an emoji wearing a shirt, like I don't know to what extent that is like promoting those ideas, but I guess, it's putting in front of kids. So
yeah. It's putting in front of kids. It's also like, if there is a person who already has concerns over the objectivity of what's going on, that's another.
Well, that could also be the source of his concerns. I would guess
it could be the source of his concerns. It's hard for us to say. We're only speculating whether it's the source or it's just like sort of the cherry on top of his concerns. I mean,
or it's just an easy thing to point to, right?
Yeah, exactly. So he suggests that, what if this emoji was wearing a neutral shirt, like the school mascot or something like that? Maybe that would cause parents to ease up a bit, is kind of what he says. Like, hey, if we tone this down a little bit, maybe parents will back off.
Yeah, but now my lawyer brain is screaming viewpoint discrimination because those are both expressive.
Yes.
Maybe it's a limited form. Let's see what their dress code policy says.
Oh.
Because like if this is a teacher in school wearing this shirt, like is there a dress code policy that says like political slogans or something like that, right? Like
right. But if not, it's potentially viewpoint discrimination.
It could be, right?
Yeah, exactly. So I think, what Chris is kind of saying is like, we can't tell them to take that shirt off if we don't have a dress code thing that is sort of applied equally to all groups. And we just say, you know what, you don't wear that shirt because it's causing some problems in the parent community. That teacher could have a valid claim of viewpoint discrimination. You're suppressing, this speech is protected. Right.
Depending on if it's pursuant to their official duties and all those other things that we're going to talk about in
just a little bit,
couple minutes.
Yeah. So, again, we're at a point now where things have escalated. Okay. It was all parent, teacher, principal, and now the superintendent is involved.
And apparently Flynn is speaking for
a group of parents,
a group of people, right? So like he's kind of a spokesperson at this point then,
or
at least presenting himself as such.
Yeah, maybe not. I mean, as a former principal, I can tell you many times when parents said,
royal we.
Yeah. said, I've spoken to everybody about this. Everybody feels the way I do. I'm like, okay, really?
We are very upset.
So about a week after this, we got another email and things escalate even more. So Flynn emails the superintendent stating that they were removing their kids from the Dedham Public Schools.
Wow.
And he provided a whole list of grievances that led to that decision.
So like 1 week after emailing the superintendent, he pulls his kids out of school?
Yeah. Yeah.
Jeez. Okay. He is feeling strongly about this.
He is all in. Or all out.
All out. We've been doing this show too long.
Way too long together. All right. So here are the list of grievances that he includes here. 1, being purposely misled about the social studies curriculum. 2, the lack of notice about the changed standards. 3, the content of the curriculum, including an exercise that required students to, quote, define stereotype, prejudice, and discrimination, unquote. Honestly, listen, it depends on how that activity is done, but on its face, those are words that I think kids should learn.
Right. Yeah. It like what you got to know the context, right? Like,
yes, exactly.
Right. Was this like, hey, let's study the civil rights movement, or hey, let's, maybe it's a social issues class or something like that. Like,
yep.
Yeah.
So number 4, the teacher emoji wearing the Black Lives Matter shirt. That, according to Flynn, he said that is, quote, the polar opposite of teaching lessons objectively. Maybe, maybe not. And the last one, material in the social studies curriculum that he felt suggested that police are a risk factor for Black men, which he took offense to since he had law enforcement officers in his family.
Okay. All right. So process and content, like it's not just what you did, it's how you did it.
It's how you did it.
Right.
So the superintendent responds and basically asks Flynn, let's meet. Let's talk about this. Okay.
Good. Yeah. Let's bring it down a little bit.
Yeah. That's always a good, I said it in my class last night. I was like, listen, if there is a parent who has a very strong concern about something, just don't waste any time. Just meet with them. Do it in person if you can. If you can't, do it on the phone. Don't do it via email. Just get together and do it as quickly as you can. So he kind of seemed like he did that in this case.
And that's why I'm highlighting some of the process stuff too, because the process stuff is stuff that you have a little bit more control over.
Exactly.
Right? Because if it's the contents coming from the state, you don't have control over that. But, if you engage people, engage stakeholders, meet them where they are, make them feel listened to, like that can help alleviate some of the other concerns about the stuff that you have less control over.
Exactly. So they meet. Unfortunately, that meeting probably did not go very well, okay? Because a day after the meeting, Flynn sent another email, but this one went to his family and friends, as well as a few members of the school board.
A few members? You said that so casually. Just a few members of the school board.
Yeah, friends and family, and just a few members of the school board.
Right. Again, high school football coach.
Yeah, he's connected.
Right?
Yeah, exactly.
Yeah.
Exactly. So obviously, this is where things, go off the rails a little bit, as we say.
This is no longer a contained situation, right? Like it's not just between Flynn and the principal, Flynn and the superintendent. Now it's got some legs.
Yes, exactly. So in that email that he sends to friends and family and some school board members, Flynn says that he came away from the meeting with the impression that the superintendent and the Dedham Public Schools supported the Black Lives Matter movement. Okay.
And remember, again, this is
2020, George Floyd, very fresh. Okay. Flynn also expressed that the superintendent didn't care that his teachers were, quote, indoctrinating 12-year-olds. So that was, I would say
I think we've identified what his concern is.
Yeah. The email also accused the superintendent of not caring about the people in his town.
Ooh, that's a different kind of thing. Now we're lobbing some at the superintendent, right? Like,
yes. Who is your boss?
Or your boss's boss, right? Like,
exactly. Right.
Right. Because that's not complaining about the curriculum or how it was done or what it was done. That's saying this person has some personal failings that make it less likely that he's going to do a good job.
Yes. And as I know you will talk about, when it comes to this kind of stuff, the courts have been pretty clear. There's matters of public concern, things that are important to the community. And then there's other speech that isn't really protected as much, like if you're complaining about your boss or, those kinds of things, right? That is not protected.
Right. And with all of this speech stuff, the context and the content is everything.
It is.
Mhm.
So obviously, this email gets back to the superintendent.
Did it?
It did. Well, I mean, look, listen, it went to friends, family, and members of the school board. Okay.
Who, in most districts, I don't know how Massachusetts does it, hire the superintendent.
Yes.
So, like, they're the superintendent's boss. So you just sent this out to your
to the boss's boss's boss.
Right. And you can imagine the school board member just being like, hey, deal with this. Right. Like, and then the response is like, I thought I did.
Exactly. And now all that Flynn is basically saying here in this email is like, I don't think that the superintendent had any desire to compromise. And if the teacher taught the course objectively and removed the Black Lives Matter thing, everything would be fine, is kind of the argument that Flynn is trying to make here. All
so
right.
Then the process stuff sounds like it's less important to the
that's kind of what
stuff, right?
Yeah, that's kind of what it seems like.
Yeah.
So, like I said, superintendent gets that email forwarded to him and probably wasn't too happy about that.
Probably understandably.
Yeah. So it was around that time that he started wondering if Flynn maybe shouldn't come back as the football coach in the. Yeah. Maybe he's not the right person to represent Dedham High School as their head football coach. All right.
Okay.
So over the winter, this led to the superintendent to have a number of conversations with other school personnel, like the high school principal, the school board, school attorney. You know, he's talking to all the people he should be talking to about not renewing this guy's contract. If I don't renew this guy's contract, what am I dealing with? Do I have grounds, blah, blah, blah.
Yeah. Always good to involve an attorney at that stage.
Says the attorney.
Who else?
I'm not arguing.
When in doubt, talk to your lawyer.
In January of 2021, it becomes clear that there was going to be a football season the next season due to the COVID restrictions being relaxed. So the superintendent has to make a decision. Do I renew Flynn's contract to coach or do I let him go?
Right. This is the moment.
This is the moment. Guess what he does?
I mean, I think we already said what happened, didn't we?
Yeah. Okay. So we said what happened. So has a meeting and basically says, I'm going to give you, Flynn, the opportunity to apologize for the statement that you made in your email. And Flynn says, no, I'm not going to apologize. And instead, he stated that he did not believe that equity is effective in certain situations.
Huh.
Yeah. Huh?
I need to know more context for that because,
I do too.
I guess, maybe the school is saying, equity is really important to us. That's why we're taking this all so seriously. And, maybe he's kind of, challenging that value.
I don't know.
I don't know.
I don't know. But that's what he said, and that's interesting. So, because he said that, and because he said, I'm not going to apologize, the superintendent told Flynn he's not going to be reappointed as the head football coach. So,
thank you. Goodbye.
Yeah. Superintendent sends a letter to the football team and their parents to let them know. Here's what that letter said. It said, we are writing today and are sorry to inform you that Dave Flynn will not be reappointed as the head coach of Dedham High School football. We met with Mr. Flynn today because he has expressed significant philosophical differences with the direction, goals, and values of the school district. Due to those differences, we felt it best to seek different leadership for the program at this time.
Huh. I wouldn't have written it like that.
I would not have written it like that either.
You just admitted you fired him for his speech.
Exactly.
Right? As my father-in-law would say, you can fire someone for a bad reason, for a good reason, for no reason, but you can't fire someone for an illegal reason.
Yes. Smart man, that father-in-law of yours.
I think so too.
I was reading that and I was like, he will not be reappointed as the head football coach of Dedham High School. And I was hoping that it was kind of done at that point. Thank you for letting us know. That's it. But no, he goes on to say, he disagreed with us.
And I think that, there's a way to do that too, right? Because what this letter doesn't say is kind of what impact that's going to have on the school community, right? This letter doesn't say we value these things.
Yeah.
And he articulated that he's not going to do the things that we want him to do. And that's a totally different letter, right? But this is not about his coaching. It's not about what he's doing as a coach. It's about his advocacy for his daughter's middle school curriculum. So there's a huge difference between his employment to me and the things that he's advocating for. And the school hasn't connected the dots for me.
Yeah.
Right? About what does this have to do with his employment?
Yeah. Because right now they're completely separate issues. He's a public citizen. He's a dad advocating for his daughter. Very clearly a matter of public concern, which is the curriculum. Okay.
Right.
And then there's the way the school is kind of presenting it. Like, this guy doesn't agree with us.
Right. Which, is raising some massive red flags for me because there's no political litmus test for public service, right? Like just because they don't see eye to eye with you, that's not a good enough reason to do something like this. So I understand the school's perspective, I understand the dad's perspective. He feels passionately about this, but
I know.
I wonder if this letter went through the attorney.
I was just going to say that. Like, I'm kind of surprised that it sounds like it didn't, even though the superintendent clearly consulted with the attorney on whether or not to non-renew Flynn's contract.
Who knows how involved they were at this point, but
Exactly. Yeah. But that's a good question. All right. So Flynn gets non-renewed. What happens, Chris?
Well, he brought a lawsuit. Obviously wasn't too happy with that decision. And it's probably no surprise because this is chalk and gavel. So Flynn sued the superintendent, the principals, and the athletic director, alleging that they violated his First Amendment rights when they decided to not renew his coaching contract.
Okay.
So, this is a fairly straightforward case. There's only, the free speech claims. There's also a right to petition claim, but that was pretty secondary, not really significant because it wasn't about his right to petition the government. He was more just kind of talking to the public. And so the case progressed. They did some discovery. They exchanged documents, interviewed witnesses, did depositions, and then the school defendants moved for summary judgment.
Okay.
And Jamie, since I know you're such a big fan of the Federal Rules of Civil Procedure, just so you know, that's Rule 56. I know you've mastered 56. Rule 12, B6 motions.
Yes. This is just a straightforward 56.
I'm sure it's got some subsections, but I don't know them.
Okay. Motion for summary judgment 56. Gotcha.
You've got 2 rules of civil procedure down now.
Yeah,
I think you're almost there.
I'm on my way to my JD.
Yeah, there's at least 54 more. So summary judgment, we've talked about it before, but it's basically saying we don't think there are any factual disputes here about what happened and that mattered to the outcome of the case. And even if you, judge, think that everything goes in favor of the other party, so you make all the inferences, all the assumptions that would help them, we still win as a matter of law. Basically, you're saying we've got enough here. There's no dispute about what happened. Or if there is, it doesn't matter, and we think we win. And so that's what the court is trying to decide here, is whether or not the school district is entitled to judgment. So let's talk about Flynn's free speech claim.
Okay.
We talk about free speech a lot. It's really important. But to make a First Amendment retaliation claim, you have to show 3 things. You have to show that you suffered an adverse action from the government, that you were engaged in protected speech, and that your protected speech was a substantial or motivating factor for the adverse action. So did something bad happen based on your speech that was protected?
Yeah.
Pretty simple.
Okay. Yep.
2 of those here are slam dunks.
Yeah. Something happened because of your speech.
Something happened, non-renewed. And because of speech. The letter literally said, due to you repeatedly expressing philosophical differences, right?
Right.
Bam. 2 elements. Done.
So the big thing we have to wrestle here is, was that or was that not protected speech?
Right. Exactly. And that kind of can be the big question in a lot of this stuff, especially in the employee context, because we've talked about it before, but public employees have different or transformed free expression rights because of their public employment.
Yes.
So, public employees don't surrender their First Amendment rights simply by accepting public employment, but
those rights are limited.
Right. Because in certain circumstances, the First Amendment does protect their speech, but in other circumstances, the government's interests as an employer kind of override those free speech interests.
Right. And so one of the cases,
a balancing test.
Yeah. And one of the cases that sort of carries one of the components of how we assess this stuff, the Garcetti case, a matter of public concern. Is the speech that's in question here, is that something that the community is going to
care about?
Right?
Or is it a
not?
purely internal employment matter?
Exactly.
Those tend to be kind of the two sides of that spectrum, right?
Right.
Yeah.
Right.
So this is often called the Pickering-Garcetti framework because there's a number of questions that we kind of just have to work through.
Right.
If you're interested, there's a lovely flowchart in the Principal's Legal Handbook on this.
Oh, yeah, that's right. There is.
So the first question you ask within Pickering-Garcetti is, was the speech pursuant to the employee's official duties? Essentially, was this something that the employee gets paid to do in the ordinary course of their work? Because if it's something that they're paid to do, like that's essentially the government hiring their speech. So it's more like the government speech than it is the individual speech.
Right.
That speech is not protected because it's something that you're paid to do by the government. So the government should have some control over that.
Yes.
That's pretty easy here, right? The head football coach is not paid to advocate for
a social studies curriculum.
A middle school social studies curriculum.
Yeah. Right. High school football coach, middle school. Yeah. It's completely outside of his scope of official duties, right?
Right. Yeah. Like, maybe if he was a high school or a middle school social studies teacher who
that would be different.
Also was the football coach, like maybe that was different, but
it could be different. Not would be. It could be different.
Right? Like the second step is, are you speaking as a citizen on a matter of public concern? Right. And we've already kind of talked about like public concern, like both Flynn and the school agree that this is absolutely a matter of public concern because the public has a vested interest in the content of the public school social studies curriculum, right?
Absolutely.
Like, so no issue there. The challenge though is like, is he speaking as a citizen or is he speaking as an employee? So Flynn is arguing that he was acting as a concerned parent, right? Like, that's what concerned parents do. They raise concerns to the principal and so forth. But the school is arguing that Flynn was really using his position as the school employee to work his way up the chain of command and that he was speaking as a representative of the school. So the school tries to argue that because Flynn's email signature included his position as the head football coach, he was speaking on behalf of the school as an employee. It's a really attenuated argument because the court looks at that and the court is not convinced. Like,
okay, so they had the same face.
Flynn went up the chain of command. Yeah, but that's what a parent would have done. He did all of this because it was his daughter in the class. Like,
it does. It's just because he happened to use his school email to do a lot of that communication.
He didn't use his school email. He used a personal email
with his school signature.
Email, it had his position was in his email signature on his personal email. Like, oh, and by the way, I'm the head football coach, right? Like,
well, that doesn't.
Probably along with whatever his full-time day job was, too, right? Like,
that does. Okay, I'm not convinced either.
Right. Yeah, and neither was the court. So there you go.
Okay.
And, the court looks at this and like, look, this has nothing to do with football and everything to do with him as a parent. So like, this is clearly him speaking as a citizen on a matter of public concern. Like, he's not doing anything else that a concerned parent, not a head football coach, would have done.
Right. Okay.
Right?
Okay.
So for me, that leads to the hardest question in this case, Pickering balancing test. So, for Pickering-Garcetti, we ask our three questions. Was it pursuant to your official duties? Were you speaking as a citizen on a matter of public concern? And then if you were speaking as a citizen on a matter of public concern, we have to do this balancing test where we look at the employee's interest in their speech and the value of that speech versus the employer's interest in kind of the sound and efficient operation of the workplace. So, on the employer side, we look at things like, does it impair discipline by superior? Does it disrupt harmony among coworkers? Does it have a harmful effect on working relationships? Does it impede the ability of the speaker to perform their job? Like, those are all questions we have to ask as we kind of balance the free speech rights against kind of the employer's rights or the government's rights as an employer. Because we don't want, we still want the government to be able to do its job, essentially.
Yes.
And so the school here is arguing that Flynn's email and the fallout hindered the efficient operation of the school and its educational mission, since Flynn's views were directly contradictory to the school's goals of advancing diversity, equity, inclusion. And for the school, this justified not renewing his contract because, there were irrevocable or irreconcilable philosophical differences that would have led Flynn to undermine the school's curriculum and its values as his position as head coach.
I am really fascinated about how the court addressed that, because everything else seems pretty simple, seems pretty cut and dry, but I'm very interested to know what the court thought about that. Are you going to tell me?
No. I was just going to
just toss it out there and say, have a nice day.
Because it is like, it's one of the keys to this case, right?
Yes, exactly.
Because the school district basically has two arguments for why it non-renewed Flynn, because he had philosophical differences. And then they add another one that like his derogatory marks towards the superintendent, like those were enough to kind of disrupt the harmony and the working relationship between Flynn and his ultimate boss. And like, it also kind of eroded the boss's authority over his employees. Right. And the court looks at both of those arguments in turn. And, it looks at that argument about like irreconcilable philosophical differences, and it rejects that argument. It says like, look, just because Flynn disagreed with you all in a matter of policy, like, how did that disrupt the school?
Right.
What impact did that have? Why did it say that he was unable to continue in his role?
Yeah.
So the court kind of like pretty much dismisses that for exactly the reasons that we kind of talked about earlier. Like the school didn't connect the dots, essentially. Yes, he has philosophical differences that may run afoul of your deeply held beliefs.
But that's not a reason to let somebody go.
Right. Until you can connect it to an impact or like, what's it going to do? How is that going to undermine what it is you are doing? Right.
Yeah.
So like, I think that's probably the right decision here, because like the school didn't really talk about why those philosophical differences would make it harder for the district to accomplish its goal, or what impact that would have on Flynn's like kind of domain of influence, right? Like, which, it's kind of the football team and whatever else.
So the school lost.
The school didn't win on that argument. And, the school could have put on evidence that like there would have been those kind of impacts, right? So like, think about the teacher we talked about in episode 26. We talked about a teacher, and I think it was West Virginia, who was teaching like world history and expressed some pretty racially insensitive stuff on her social media pages. And the court in that case sided with the school because, there were obviously some ideological differences there. But the court said, like, look, the school has put on more than enough evidence to show that this kind of speech and these ideas, like, undermine her ability to be an effective teacher, given her subject, given the content that she's teaching, given the school's goals, and the racial makeup of her students. So like it connected the dots between what she was saying, what the school wanted, valued, and the impact on the students, right?
Exactly.
And here that's not.
It wasn't evident. Presented. Yeah.
Right. And, maybe that evidence existed, but it's not in the opinion. So like, I'm wondering if the school just wasn't able to produce that evidence or didn't explore that part of things, because they've got another argument which actually does succeed.
Oh, okay.
Yes.
It's not over.
It's not over because the court looks at Flynn's statements about the superintendent, and the court says that, you know what? Yeah. An employee like this insinuating that the superintendent doesn't care about the community, that they're not listening, like they're not able to do their job or do their job well or effectively, like that itself could
undermine,
undermine his authority, undermine his ability to run the schools, could also undermine the ability of Flynn to work with, his immediate superiors and things like that. So like that for the court was enough. And the court basically says like, we haven't pointed to anything happening yet, but like, you don't have to wait for something like that to happen.
Right.
Because that's a pretty we were able to connect the dots there.
Yeah. That's a pretty cut and dry.
Yeah.
Had Flynn just left that part of his editorialization out of his communications, he might have been on some really solid footing.
Right. Yeah. Because the court even said like, you can't fire someone just because they politically or ideologically disagree with you. Like that by itself is not enough. But adding that personal attack, that's what
you just shot yourself in the foot.
Exactly. That was what the district hung their hat on and what the court hung its hat on.
You just fumbled the ball.
And you said you couldn't do sports. Look at that. Sports reference.
That's it. I'm out. I'm done.
Right. And, all of this is to say, the speech wasn't entitled to First Amendment protection because of the Pickering balancing test. So Flynn loses his First Amendment retaliation claim. The court grants the school district's motion for summary judgment. So case closed. Flynn's non-renewal did not violate the First Amendment.
Wow. After all that,
after all of that, right?
Just the comments he made about the superintendent.
And that's such a fine line, right? And I think that's kind of one of those situations where I could have seen the court going either way, because the statements weren't that inflammatory, but like it's also the superintendent and like, they're responsible to the community. So like that's a really important relationship.
Mm-hmm.
But like if it's just this teacher expressing philosophical differences about the direction of the district, like that's speech that I would really value. And, like I had a law professor say that if the First Amendment only protects speech you like, then it's not really doing much. And while I might not agree with Flynn's perspective on the curriculum and whatever,
he's got a right to say it in most circumstances.
And I think that's important that, he doesn't get fired for it until you can prove kind of like the disruption to the district, right?
Mm-hmm. Absolutely. That's very interesting how all of that played out. Yeah.
It is. It's an interesting case for drawing lines, right? And I think it's good to compare this case to what happened in the case from episode 26.
Yeah. Exactly. Good pick, Chris. Thanks for picking that one. Well done.
Thanks.
All right. Well, watch your speech, teachers, but at the same time, you've got significant protections. That Constitution gives you significant protections, but just there are some lines. And hopefully we've illustrated where some of those lines are today.
That's the goal.
Exactly. So what's our homework, sir?
Your homework is to go draw some clear lines, I guess, or recognize where the lines are. Also, probably don't disparage your superintendent, even if you disagree with them, right?
Yes, that's right. That's right.
But your real homework is to like, rate, review Chalk and Gavel wherever you get your podcasts. Subscribe on YouTube, all of that stuff. Give us a thumbs up. You can find us at Chalk and Gavel on social media, or you can go to our website, chalkandgavel.com, find our teaching guide and our feedback form. You can also find our Patreon and support us with $2 a month. That goes a long, long way in helping us keep this show running and keeping the lights on.
Exactly. All right, everybody. Well, I hope you enjoyed episode 53, and we'll see you again in a couple of weeks for episode 54.
Is that the next one?
That's the next one. Have a good one, everybody.